All right, hi everyone. How was your summer? Everyone enjoyed themselves? Well, welcome back. How many classes do you have before me? 2 or 3? Am I your only class on Monday? Oh, what do you have after this? Oh, that's a late class, isn't it? Yeah, not good. Anyway, well, welcome to Property, Property 2. Before I start, I have a little treat/bribe for all of you. If you notice, there were some cookies there, right? Anyone take any of them? Okay, those are for me, actually. And my first day of teaching ever was my birthday, and I brought cookies, and people seemed to like it. So I will repeat that tradition, and I have many more for everyone. So please pass these around. I never know the best way of doing it. Usually the corners were the best. It gets worse from here, I promise. Everything that was actually the highlight of the entire class, or something like that. Okay, so everyone, welcome to class. Enjoy the cookies. Try to have some delight before we begin. So you're probably sitting yourself asking right now, I took property already, right? Didn't I already learn property? Didn't I learn the rule against perpetuities and future estates, all that garbage? Okay. So this is Property 2, in case you're in the right place, all right? These are very different classes, and you will more likely than not like this class more than the other one. Why? Because it's about modern stuff, okay? Just about everything we do in this class will be based in at least the 20th century. A couple exceptions here and there, but virtually everything we do is modern, so it's a lot easier to relate to, okay? I will not ask about the rule against perpetuities, I promise. I will not ask you about future estates. I will not ask you about any kind of shifting executory interests, okay? That will not be this class. But there are a lot of other things I will ask you about, okay? The topic we do today, adverse possession, and we'll finish it up tomorrow, doesn't really fit anywhere. It's kind of a nice bridge between the two classes. If you notice in your textbook, it's actually in the very beginning, but for whatever reason, this school does in the second semester. But most of what we'll do this term actually involves the relationship between property and the government, right? Almost everything you did in Property 1 was person X sues person Y, 2 people chasing a fox and one gets it, you know, those kinds of cases. A lot of what we do here actually involve governments, land use, regulations, takings, as well as we do things called covenants, easements, different restrictions you can put on the use of land that are actually enforced in courts, okay? So that's a high-level overview of what we're talking about. There's still going to be a lot of really not interesting topics we have to cover, as with all law school classes, but I will try to make it as fun as I humanly can. As well, we're relevant, unlike Property 1, there are some applications of Texas property law, and we will discuss them where relevant. For example, today we'll talk about Texas adverse possession. I promise you'll probably not remember any of it for the bar, but at least it'll be burned somewhere in your head, so when you cram in 2 years, it will come out and refresh, okay? All right, so first, I assume everyone was able to find the syllabus okay? And the textbook. Okay, so just a note, we're going to stick with the 7th edition. I originally went with the 8th, and then someone told me that you all have the 7th edition, so there's absolutely no reason to change. It's very frustrating when they change textbooks, because I actually, for my Property 1 class, I had to switch. They changed, out of a 1,000-page textbook, maybe 50 pages were actually changed. There's very little that was ever actually changed, so I'm glad we can stick with it. They actually eliminated a couple cases I liked, so it's good we can stick with the old book. Okay. So first of all, the way to get around in this class will not be on Stanley. It's just go to my blog. It's joshblackman.com. And you'll see there's going to be a link for classes right there. It's a little too small for you to see, but you can see in your screen. And once you go to the link for classes, there'll be a listing, and it'll say Property 2, Fall 2014. Okay, when you click on that page, it will tell you everything you need to know. All right, at the very top, there'll be a syllabus. Okay, I'll do the syllabus first. Okay, so the overview of the course is Property 2. As far as the exam, people always ask about this on the very first day. I put all my old exams online. They're there. You can read them. They won't make much sense yet, but they will soon enough. I also include the A+ exam from each semester, so you have a sense of, you know, what's the best person, how they did, and these are your peers. Attendance, I'll pass around a roll. I won't do it today, but I'll do it on Wednesday. Also, I'll do the seating chart on Wednesday, so If you don't like where you're sitting, or you think your neighbor like smells bad or something, you still have time to switch in time for class on Wednesday. Okay. I expect you all to be prepared, and I mean this quite literally. So the way I do recitation is probably different from how your other professors may have done it, in that I try to call on as many people as possible. So there are about 55 or 60 people in this room. I'll probably call on about half of you in any given day. And the way I do this is by asking each person one question. So I'll start in a corner, like with this guy, and I'll go 1, 2, 3, 4, all the way around, all the way around, all the way around, all the way around, all the way around. And each person will get one question. Okay? The trick about this is it has its pros and cons, which I'm fully aware of. The pro is it forces you to pay attention, right? You need to listen to what your neighbor said, because if the person to the left of you is called on, you know you're next. You need to listen to what your neighbor said, because your question will be a follow-up to that, right? And if you don't get it, then you break the flow for you, the person to your right. This also makes you pay attention very well, because instead of one student being on call for 25 minutes at a time, standing up, whatever, everyone will get a question. I can probably do the entire class into every student within 2 classes. You will get called on once a week without fail. So please take attention to be prepared. The readings aren't that bad. I work very hard to keep them under 25 pages. I think I maybe go over that once. Also, I make a promise to you, which I've kept every semester. Whatever the readings say for a given day, that's what we'll cover. We don't fall behind. I keep us on schedule. It's really difficult if you think about it. But we will always finish on time and start on time. It'll never be read 20 pages ahead. You always know what's been assigned to you for a given day. So if you need to read a couple weeks in advance, get your stuff done, whatever. But this semester is set in stone. I've never actually fallen behind. I'm not anticipating doing it this semester either. There's lots of time for discussion, but I build that into the calculus. Okay. All right. Any questions so far? Okay. Now, as far as the classroom participation, in addition to the calling on everyone going around a circle, I do a couple things which also might be a little bit different. First, I don't use PowerPoint. I actually will develop and type notes for you in real time. Okay, I type them up here. You'll see hi. Okay. These are not a substitute for your notes. They're not meant to be. This is because I can't write by hand. My muscles have atrophied. Right? I'm somewhat sarcastic, but I can't really write the board. I have no penmanship. It'll look like garbage. So it's a lot easier for me to simply type up here. Okay. But this does have certain benefits. Okay, what's the benefit? This is a Google Doc, which some of you might know about, which are shared, which means that you can go to the class homepage. Okay, this is what the class homepage looks like. This is the post for today, and you'll see a link. It'll say the lecture notes are in this document. Right? If you click that, then on your very screen, these notes will pop up. What students have done in past semesters is keep this in one window and another, or not at all. It's totally up to you how you want to run this, but now you can see whatever I'm typing on your own computer. Okay? If you want to go back after class and double check stuff, you can. It's entirely up to you. If you don't have a computer, that's also fine because I keep it up here, so you're not missing anything. Okay? The second thing that I do that's probably a little different is I have something called a back channel or a live chat. So if you go back to today's classroom page, you'll see there's a link. It's a little small, but it says a live chat. Okay? If you click that link, you'll find that a window pops up which allows you to ask questions. So, whatever, right? The reason why I have this is that in any given class there are 60 of you, and only one can talk at a time. I'm sure this has been something which you've realized throughout law school. And it's often the case that you might have questions or comments or perhaps a news story or a link, which you're welcome to share with me and share with the colleagues. It's often not very easy for you to dictate a link, so if you have a link to a story, you can put it there. If you have a question that might be somewhat tangential and you're not sure if it fits in, you can put it there. I don't demand use your real names because I found when I do that, no one actually uses it. Pseudonyms are fine, but I will stress that if you abuse it, I'll shut it down very quickly. So know that. But I've done this now for 3 years, and I've never actually had any significant problems with this. So it varies by usage in class. Some people use it a lot. In the last class, I got like maybe a dozen questions. Some classes I don't get it at all. So it's entirely at your disposal whether you want to use it or not. Okay? All right, any questions on that? So whenever you walk in, this is what you're going to see on the screen. You'll have these two windows, which is the notes and the chat. Use it or not, it's up to you. Okay? I also have on the class homepage a lot of pictures. I love pictures. Very often these cases can be very dry, and they become almost detached from reality. So to the extent I can, I try to humanize everything you do, because eventually you'll be working with humans. That's what lawyers do. So I'll show you maps of the places, pictures of the people involved. I have lots of videos. I have lots of things that will hopefully make this class a little bit more interesting. So everything you need is here. It's a full resource. Okay. One other note to stress. I put all the lectures on YouTube. Okay. They're all on YouTube. I actually stream them live from right here. Wait for the camera. And they're available immediately after class. Okay, but here's the rub. So first of all, I'm taking attendance, so the temptation to skip class, that's a check. But more importantly, this camera doesn't pick up your voices. Okay, it only picks up mine. So if you try to rely on the videos as a substitute for class, you will miss probably 80% of the class. It's not a good substitute. What's it best for? If you miss class and your friend takes some notes, you can help fill in the gaps. Or maybe if you take your own notes and you weren't sure about certain context, go back and watch it again. Students tell me that they actually, before final exams, rewatch entire classes, which is something which I would have loved to do when I was in law school. Say if you missed something, one topic just didn't make sense to you. So it's there, but don't abuse it. And I promise you, if you try and use only that, you will be missing so much. One other note, which is not really so much for you, because now you had a full year of law school in your belt, but I give this stick to the one else also. Regarding outside materials, you're free to use whatever you want. You can use whatever book, whatever source you want. There are lots of good commercial sources, horn books, whatever. But the only things that I will test you on are the things I talk about or things in the reading. Okay? It's very likely that the things you read are correct in the book. I can't vouch for them. But it also happens that you might be reading something which is totally different than what I'm teaching. And it becomes painfully obvious on the final exam, usually 1 or 2 every year, where the person writes about something we never covered in class. And it becomes painfully obvious that they looked at some commercial source and they didn't get what I wanted to. Okay? So do the readings. Do them. The readings are manageable. It's usually 20, 25 pages in a given night. And if you look at the calendar, we have a nice stretched out, spaced timeline, so it's not too compressed. I think you should have enough time for everything. Okay? Let's see. As far as office hours, I'm available to meet immediately after this class. If you just want to come talk to me in the hallway or whatever up here, that's fine. If not, between 1 and 2 upstairs. And since I don't think any of you have class at that time, that shouldn't be an issue for any of you. And if you need to email me a different time, that's fine. If you want to reach me, rather than the South Texas address, I have an email address up here, which will get to me much quicker. This right here, Prop2, Fall 2014. You can get to it on the syllabus. That'll get to me much quicker than my South Texas email address. I have a special filter. It alerts me to actually read it, and that way I'll be in close contact with all of you. All right. Questions? Anything formal procedure before we move on? No? Okay. All right. So let's get started. And as I mentioned, adverse possession is kind of a weird topic to start off on. I'm not exactly sure why it's here, why not in Property 1, but it does provide a nice bridge between the two classes. Because invariably in Property 1, all of your stuff was how do you obtain property, how do you find property. And Property 2 is a lot more about disputes, where person A says I have this problem, person B has this problem, how do you resolve it? So there are going to be a lot more cases we read about this year. So before I even start the lecture, I want to play a video, and this is actually about 2 years old now, but it's from a suburb of Dallas involving a squatter. Some of you may have heard this story in the news, but let me play it and you can watch it.
What if you could live in a new home without a mortgage? A man in Flower Mound has done it, moved into a $300,000 house, and he only paid $16 to do it. It's a little-known Texas law, and the foreclosure mess could have him living on Easy Street, but his neighbors, well, they're less than thrilled. Channel 8's Casey Norton has this exclusive from Flower Mound.
Flower Mound's Waterford Drive is lined with well-manicured $300,000 homes. So when a new neighbor moved in without the usual sale, mortgage-paying homeowners had a few questions.
What paperwork is it and how is it legally binding if he doesn't legally own the house? He just squats there.
Lee Lowry and her husband told me the house down the street was in foreclosure for more than a year. The owner walked away, then the mortgage company went out of business. Apparently, that opened the door for someone to take advantage of the situation.
Watch this part.
Kenneth Robinson told us he's no squatter. He says he moved in on June 17th after months of research about a Texas law called adverse possession.
This is not a normal process, but it's not a process that's not known. It's just not known to everybody.
Robinson says this piece of paper gives him rights to the house.
He says affidavit of adverse possession. Come back to this in a minute.
It's an online form he printed out and filed at the Denton County Courthouse for $16. It says the house was abandoned and he's claiming ownership.
I went through, looked at it, and added some things here, you know what I mean, for my own protection.
The house is virtually empty, just a few pieces of furniture, no running water or electricity. But one says just by setting up camp in the living room, Texas law gives him exclusive negotiating rights with the original owner. If the owner wants him out, he would have to pay off his massive mortgage debt, and the bank would have to file a complicated lawsuit. Robinson believes neither is likely, so if he stays in the house, after 3 years, he can ask the court for the title. That's your goal eventually, is to have title of this home, to be the owner of this home.
Absolutely. And on a record, you know what I mean, at this point, you know, since I possess it, I am the owner now.
Robinson posted no trespassing signs after neighbors asked police to arrest him for breaking in. But Flower Mound officers say they can't remove him from the property because home ownership is a civil matter, not criminal. Lowry and her neighbors continue to look for legal ways to get him out.
Or if he wants the house, buy the house like everyone else had to. Get the money, buy the house.
Robinson says he's not buying anything. As far as he's concerned, the $330,000 home is already his, and he has the paperwork to prove it. Casey Norton, Channel 8 News.
Now, foreclosures are down for the 6th month in a row in North Texas. August filings fell 14% compared to last year. However, something to keep in perspective, foreclosures are still 313% higher than in August of 2000.
Okay. All right. Can everyone hear that? The volume was a little low. So the general gist was, they went from Flower Mound or thereabouts in Dallas? They went from Dallas? You know this area? It's a nice area? Well-to-do area? Okay, so this is a pretty well-to-do area outside of Dallas. And as happened a lot in the last 5 years, people took on mortgages which they had no ability to repay. And what ended up happening was the mortgage was worth more than the value of the house. So it creates this weird situation where it's actually better, in some cases, to walk away from the house, just let it go. And this has actually left a lot of houses abandoned. And squatters who perhaps didn't take property, or maybe they just Googled something, said, I got an idea, adverse possession, right? If I set up shop in that, in the Lazy Boy for 3 years in the living room, and I follow this paperwork, then I can get ownership of the house. And in fact, this is not just Dallas. I did some Googling last night, and this actually happened right here in Houston, in the Heights. Anyone ever read about this? This happened last January, I think, where there was this 90-year-old woman who'd been living in the same house for decades in the Heights. The house was worthless, the land was worth a lot of money. So after she died, these squatters moved in, and they filed similar paperwork. Now, believe it or not, Mr. Robinson actually led a legal clinic somewhere in Dallas to explain to squatters how to do this paperwork. This is why lawyers should be doing this, okay? But actually, an investigation revealed there was a ring of squatters in Houston. This was the lady. You can watch the video later if you want. There was a ring of squatters in Houston who have done this to 60 properties right here in Houston, trying to claim adverse possession. Okay? Now, Mr. Robinson, unfortunately, miscalculated. He said that the bank would not file a complicated lawsuit to kick him out. Okay, they did. It wasn't very complicated. Bank of America, not too long after the story aired, he should have stayed quiet. That was his first mistake. Bank of America filed a notice of ejection, and they basically kicked him out pretty quickly. So Mr. Robinson was out of luck. Okay? But this video raises a lot of really core issues about adverse possession. Think of the neighbor, right? The neighbor was pissed off. She's like, listen, I paid for my house. I get to live here. Why is this guy get to come in here and squat and take the house for doing nothing? Okay. So let's have a little bit of a discussion. I'm going to start in that corner because I'll work my way around. So what's your name?
Sean's all right.
Sean? Okay, thank you. Sean, do you own a house? You ever lived in a house that was owned or?
Yes.
Okay, so say your next door neighbor walked away from his house, right? And then some random dude moves in. What's your reaction going to be?
Won't be happy about it.
Why not?
Because I had to, or at least whoever I'm living with, they had to pay some money to live there, but we had to put in for it, and this guy got it free.
Okay. All right, so what's your name?
John.
John, what do you think? If you were your next door neighbor ditched the house and some random dude moves in.
I don't know. I don't pay rent for where I live now, so.
Ah. So are you free riding?
That's a deal I have worked out with one of my people I work for.
Okay.
Yeah, so I don't know. I guess he'd be upset. He owns the house.
All right, one more. What's your name?
Derek.
Derek, what do you think?
I think it's when you come down and just pay for the house. It's when you move into the neighborhood to take into consideration, like thinking things like who your neighbors are, schools and stuff like that. And then, he's getting it for free. Is, you maybe pay more for the house because it had the neighbors that did.
And what's your name? Catherine. Defend Mr. Robinson, please. You're Mr. Robinson's lawyer. You just saw him on the news and oh, what an idiot. So how do you defend him? How do you make a case for the squatter? What do you mean blend? Explain more.
By thinking the home is not being taken care of or utilized. It's just a waste of space. And so.
Okay. So what's your name?
I'm out.
Alex?
Yeah.
Is Mr. Robinson taking care of the house? We put up a no trespassing sign.
Didn't see what you were sitting.
Okay, but at least is he letting the living room fall into disrepute? Maybe. No. Didn't look clean? Look clean? Yeah. Okay. So here we have a couple different policy arguments, right? On the one hand, there's unfairness, right? It's unfair that these squatters can come out of nowhere, didn't pay anything, can just sit there and set up shop. On the other hand, they're actually perhaps making some sort of improvements to the land. They're not letting it fall to disrepute, not letting it become all decrepit. Right? He put up a no trespassing sign. I'm sure he's maintaining the locks. Although actually it gets very dangerous because very often what happens is there's no water, there's no gas. So what often happens in these foreclosed homes, they try and run a gas line from the neighbor. I'm serious. It's really dangerous. But this happens. I don't know if anyone's ever seen this. This happens a lot, and it gets to be very dangerous. Okay. So let's pretend this isn't a house in Dallas or a house in the Heights. Well, let's pretend it's just a plot of farmland. Like, let's go back to our old friend Blackacre, right? Ma'am, what's your name? Aisha. So if Blackacre is lying dormant, the owner just runs away. You think it's a different scenario if Mr. Robinson moves in and starts farming and tilling and growing plants and stuff? And
Yeah, because at least he's making use of the land.
He's basically, is that something good to be making use of the land?
Yeah.
What should society prefer, Aisha? The land lying dormant with the owner being who knows where, or Mr. Robinson, tending to the soil? So I think we all agree it shouldn't be automatic that the second someone runs away from their land, that some dude can come in, right? So what's your name, man? Haley. So what's the compromise? What's the solution that the common law reached to deal with this issue of abandoned property and people not enforcing their rights?
They forced the true owner to sell the land, and owners efforts addressing it.
At common law, how was this handled? Blackacre goes, the owner runs away, and Mr. Robinson moves in. Mr. Robinson says, hey, I'm moving in here. I'm going to be here. What are you going to do about it? How would the common law deal with that situation?
The true owner would have to eject
the
person who's adversely possessing.
And how much time would he have to eject that person?
It depends on the situation.
But what's the period called? What do we call that? What do we call that time period? The statute of limitation, right? statute of limitations. All of you studied, I guess, in civil procedure, probably in contracts, the statute of limitations, right? Now, what's your name? Kate? Katie. Katie, what's a statute of limitation?
It's a period where you have to take action on a claim, pursue a claim. If you pass that, basically out of luck.
Yeah. I mean, is anyone ever? Yeah. So it's good that the abbreviation of statute of limitations is SOL. Because if you blow your statute, you're SOL. So, and Google that if you know what that means. But has anyone ever thought of what that actually means, statute of limitations? Believe it or not, there actually was a statute. It was called the Statute of Limitations. And what did it do? It limited the time through which someone could pursue a claim, right? It said, if you have some claim, you have to bring it in 2 years, 5 years, 10 years, whatever, right? So what's your name?
Adam Boyd.
Adam, why do we have statute limitations? Forget about property for a minute. In general, what are the justifications for statute limitations?
Well, I mean, there's got to be some type of time period to bring a claim. If there's not, then virtually a claim could go on, a possibility of the claim could go on for generation after generation.
What's wrong with that?
I'm sorry?
What's wrong with that? Why is that such a bad thing?
There's just no certainty.
Certainty. Okay, what's the certainty?
Well, I mean, you said, speaking of property, for example, we talked about they come in and if you squat or if no one ejects them, nothing but statute runs, you know certainly that if he does everything right, that he is now the true owner of that property. So then when it comes to selling the property or buying the property, there's certainty with who to go to and how to go about.
Yeah, that's exactly right. So imagine, after Mr. Robinson went on TV, Bank of America said, screw it, not worth the fight. And he stays there for 3 years. And maybe he gets married, and maybe he brings a family there, and maybe he starts sending his kids to school, and maybe at one point he wants to sell the property to someone else. And at the very last minute, 20 minutes later, the original owner says, oh, wait a minute, that's mine. Now, perhaps it might not be fair for Mr. Robinson on day one to claim possession, but after 20 years of living there and raising his family there and mowing the lawn and doing all the things a homeowner would do, perhaps there's a stronger claim to it, right? So what's your name? Adam. So imagine one day that you buy a house, right, and you bought it from someone. You're living there with your family for 25 years, right? And then somewhere at the last minute, someone comes along and says, hey, wait a minute, I'm the real owner of the house. The person who sold it to you was a crook. He didn't have the correct title to it. How would you feel?
Very upset.
And what would you claim if that happened? You've been living there for 25 years with the family, raising everything.
I would claim ownership.
No, you've been living there for 25 years, and this guy says, "Wait a minute, I got the title. The title you got was a piece of junk. It was a fraud."
I mean, I bought it in good faith.
Yeah, but then what? What if the court says you should have done more research? You should have known. You should have done a title search. So, what do you say after 25 years of living there? Think about it.
Adverse possession.
Adverse possession, right? It's a little different when you talk about Mr. Robinson, but put this in your own mind. Say you or your parents were living in a house for 25 years, and the person who sold it to you was a crook, didn't actually own that land. And then the true owner shows up at year 25 and says, hey, wait a minute, that's my land. What do you all say? Adverse possession. I've been here for 25 years, right? The law should recognize certainty. Even if I wasn't the correct buyer in the first place. Everyone knows I live here. I've acted like I live here. Society's been built on me living here. So after a while, society says, you know what? If the owner of the land didn't enforce his rights, the law won't either. The law won't either. The law will treat the person who's been there for 25 years as the actual owner. Everyone see that? I mean, this is a harsh remedy. Because, I mean, on the one hand, think about you're the owner. You've been sitting on this for 25 years. You never got around to it. And then you finally bring something in court, and they say, sorry, you waited too long. Sucks to you. Right? This isn't like with an adverse, this isn't like your standard statute of limitation case where if you blow your statute, you can't file a lawsuit. Here, you lose your property. Right? You lose something you had. They're taking something away from you. which is a very extreme remedy, right? So why do we have adverse possession? One thing he said was certainty, right? The law tries to promote certainty. Another person said before, efficiency, right? We want to promote the efficient use of the land. We don't want land sitting there for 25 years being untended. We want people to be able to use the land, develop it, agriculture, farming, whatever people do on land. All right. Everyone see that question so far? Yes, ma'am.
What was the word you said? What did you say right before it?
Certainty. Yep. Certainty and efficiency. Right? Law like to promote certainty. We want to know who owns it. If they want to sell it to someone else, their family's here, we can make things certain. The law also promotes efficiency, right? You want land to be used in an efficient manner. So both of these effectively say after, say, 25 years, you snooze, you lose, right? If you don't enforce your own rights, don't come complaining to the courts. That's what Holmes said. If you don't enforce your own rights, don't complain to the courts. You had 25 years to do it. Okay. There's also another rationale, which is perhaps germane. Are you taking evidence this term? Yeah. Okay. So what's your name? Kevin. So say, for example, Mr. Robinson just got the property a week ago, right? His neighbor knows about it. Everyone knows what happened. Okay. But say instead this was a transaction that happened 25 years ago. Do you think there'll be as much testimony or relevant knowledge about what happened?
No.
Why not?
It's not present on the land and using it.
Good. So you'll learn this in evidence, but evidence goes stale, right? Like bread, it goes stale. After time, people forget. People die. Back then, there were no papers. The common law, there were no records being kept. So another rationale for adverse possession is you have to go there when the evidence is fresh. If after, say, 10 years and all these people forgot and all the paperwork's been burned, there's no way of proving it. So it also encourages people to bring actions when the evidence is still fresh. All right. Questions? Now, what's your name? Monica. Monica, tell me, what if I were to tell you that adverse possession is nothing but theft, right? It's just a form of stealing. What would your response be to that?
Well, the property was abandoned.
Uh-huh.
So the owner, by giving the land up for 25 years, has given up their rights.
Mm-hmm. Yeah. So that's pretty good. Effectively, the argument is, if you sit on your rights for all these years, you don't deserve it anymore. But what's interesting is there's actually a transfer of land with adverse possession. So say Mr. Robinson had actually managed to stay there for a number of years, and the bank never took any action, and they knew about it. He could have actually gone to court and asked for a declaration that he owns the property. The title would have actually been in his hand. So if he had been able to sit there for all those years, fighting away the reporters, fighting away the neighbors, and he finally got it, he is now the record owner. Okay?
So what's the difference between, well, never mind. I was going to say, what was the difference between the person walking away from their property and then just abandoning?
Ah, okay. So let me ask you this question. Let's see. Ma'am, what's your name? Leia. Well, let's say, for example, that Mr. Robinson wasn't so camera friendly, right? Let's say he started squatting in the house and he stayed locked up for all those years and didn't tell anyone. Bank of America never even knew about it. Could he get possession then? Why not?
Because the true owner has to know that somebody's taking away his rights.
Exactly. Right? Just because you abandon your property doesn't mean the squatter can take over. The squatter has to make it known that he's squatting, right? So if you only have abandonment, that isn't enough. That's why we have 4 elements, right? Law students love 4-element tests. Don't you all love 4-element tests? This is actually one of the few 4-element tests we'll do this year. In fact, virtually all of property is not about elements. This is not like, torts, like, what's a battery and what's negligence and what's trespass, right? Property, we don't have that. We don't have these elements. We have common law. But this one does have elements. Okay, so what's your name?
David.
David, just read off me the 4 elements of adverse possession, please.
Entry, that is open and notorious.
Okay, so 1 is entry. 2?
Open and notorious, that's knowledge only.
Good.
Continuous or statute.
Okay, so 3 is continuous. Okay, good. And what's 4?
Adverse and under a claim right.
Okay. All right. So we're going to spend the entire class on these 4 elements. So if you don't, we'll talk about them at various varying degrees of depth. Okay. That's an entry. You have to physically enter the property. You can't claim remote adverse possession. It's like, oh yeah, look at that nice house. I'm going to go squat in there. I'll stay in my own house, right? You actually have to be in there. That's why Mr. Robinson actually went in the house. Okay. So what's your name?
Mike.
Mike, what's the importance of entry? Why is that such a significant element? What does entry do?
Creates a possession of properties.
More than that, why is entry an important element in this test? What happens when someone enters the property? Think of Mr. Robinson and the neighborhood.
Well, they're exercising a dominion over the property.
What happened when Robinson entered the house?
Well, he broke in.
And who got pissed off?
The neighbor.
Neighbors. And so what did the act of entering do?
It notifies.
Yes, it's a signal, right? The reason why entry is so important is it signals to the world, I'm in, right? I physically entered. This serves as a notice, right? This serves as a notice to the world that I am entering a piece of property. All right? Now, someone posed a question here. What if I buy a piece of land for retirement and don't go there for the next many years? Land is in another state, so you couldn't have known. Really? What do you think? What's your name?
Zach.
Zach. So you buy a piece of land in Louisiana, say, right? And you live here in Houston. Some squatter comes on the land. He's open about it. Everyone knows. You don't find out. Whose problem is that?
Yes, it's your problem.
You mean your problem? Yes, not my problem. That's right. It's the owner's problem. You have an obligation, if you're the property owner, to know about entries onto your land, right? Now, again, if the person does it secretly or quietly, then it's not your problem. But if they openly go onto the land, maybe they're farming there, maybe they're chilling in your beach house in Florida, whatever, you should know. The law doesn't like to protect the property who sits on its butt for 20 years, right? So if you buy a piece of property for retirement, you got to take care of it, right? You have to have someone tend to it. And if you send someone there to take care of it, you say, hey, there's some dude living there, and you do nothing about it, okay, that's your problem. If you try and kick him out, you have every right to do so. Okay. All right, so what else? All right, so that's the entry. So the reason why the entry prong is so significant is that it signifies the, what do you call it? The act to the world of actually entering the property. Okay? What else does entering do? What's your name, sir?
Parsa.
That?
Parsa.
Parsa. What else does the act of entering do? I mean, what did Mr. Robinson say once he entered the house? What was he? What did he do after he went to the house?
What did you do after coming to the house?
Yeah. And what did he do in the court?
Oh, he affidavit, filed an affidavit.
Okay. And did you listen? He mentioned it briefly, but how many years he'd have to wait? He said 3. Close enough, right? He said 3 years, right? The act of entering starts the clock. Oh, right? We know average possession is a certain number of years, 3, 5, 7, 10, whatever it is. The active entry starts ticking the clock. Okay? So the entry is a very significant thing. Yes, ma'am.
So the affidavit, what if you entered a long time ago, and then are they just going to trust your word that you've been staying there for so long?
Okay, so we'll talk about the affidavit in a little bit, but the reason why you filed this affidavit is to create some sort of paper trail. Okay, when we talk about color of title, we'll come back to like maybe 15 minutes. Okay. All right, let's talk about the second element. Okay. So what's your name? Jordan. My favorite Biggie song, right? Notorious. What? Right? Does anyone follow the Notorious RBG? Anyone Supreme Court fan, Justice Ginsburg? There's been this entire meme of the Notorious RBG, and she actually likes it. Someone has to explain to her who Biggie was, but God bless her. So let's talk about notorious. What does this mean, open and notorious?
Pretty much you're putting the original owner on notice that they're trying to deprive them of their exclusive dominion over the property.
Exactly, right? So the first two elements kind of blend together a little bit, but effectively, like notoriety, notary, it means public. You need to make your use of the land public, right? So in effect, Mr. Robinson went on TV, right? That was quite notorious of him, right? Biggie will be proud. So we have a situation we have to be open and notorious and show to the world. The goal is you have to put the property owner on notice. Okay? You can't simply pretend. So we'll see this in the second case, the case in New Jersey, the Gorski case. There was no notorious use of the land, right? The person didn't even know that the staircase was over the boundary, right? So there was no notorious element, right? So you have to be notorious that you're seizing this land. Okay. All right. Next element. Continuous. So what's your name?
Andrew.
Andrew. So tell me about continuous.
That's basically saying within the statutory period, using the land like
Okay, good. All right. So this one is the closest one linked to the actual limitations, right? Each state has different limits set usually by statute of how many years you have to be on the property. Okay. Now, so what's your name?
Zach.
Zach. Now, does Mr. Robinson have to chain himself to the house for 3 years and can't leave at any point?
No, it just has to be regular.
Okay, good. And this is an obvious point, but people sometimes get hung up on it. You're allowed to leave the property, right? You can go to work, go to church, go to the store, whatever. But you have to use the property in the manner that the original owner would. Okay? So a trickier example would be, what about a summer cottage? So what's your name with the hat?
Hugo.
Hugo, what if there's a summer cottage and you squat there just during the summer? Have you met the period for continuous use? Yeah. Or what about a ski lodge? What if the place is only used during the winter and you only go there during the winter? Have you used it continuously? Okay, that's right. So you often have to look at how the property would reasonably be used. You can't simply say, oh, he was only there for the summer, that doesn't count. Okay? Also, this isn't just a matter of time, but it discusses how much of the property are being used. So what's your name? Blaine. Blaine. So there's a case mentioned in the reading, this Ewing versus Burnett case, right, which involves this huge dump lot of all different garbage. Are you required to actually use every inch of that dump lot to continuous use? Okay, that's right. Even if you only use part of the land, you're probably going to be okay. You effectively have to use the land the way the true owner would use it. That's your test. It has to be used as a true owner would use it. Okay. There's a question here. Is it not true? Don't start questions that way. It's not cross-examination. Okay. Does notice need to be actual or constructive so the reasonable person would know? You can have constructive notice. You don't need to take out a newspaper ad. If you're on the land and you're farming it and you don't tell anyone and people see you farming, that might be enough. This is a very fact-intensive inquiry. All right. All right. So okay, so that's continuous. The last one is the hardest one to define. Okay, and if you notice, your book doesn't really define it, which I find somewhat frustrating, but it's actually deliberate. The reason why is that the last element means a lot of different things. Okay? And we're going to talk about these, but the adverse claim can refer to a claim of title or a state of mind. Okay? Okay? The reason why this last element is confusing is it refers to different things. So the easier one to understand is state of mind, and this is what the Valkenburgh case tries to get at. But it has to do with, was this a mistake, right? Were you squatting here because you thought it was yours, or are you a hostile person, meaning I knew this was yours, I'm going to squat here anyway, right? The claim of title refers to something a little bit different. Do you have some sort of legitimate claim to the land, right? Maybe someone gave you a fraudulent deed, like the example I gave to the gentleman in the back, right? Maybe someone gave you a fraudulent deed that looked good but was actually bad. Maybe you think you actually own the land and there's some sort of dispute, right? This term claim of right means a lot of different things. So I'm going to urge you to try and be a little bit context specific and look at how the court's using it. Because even in the two cases we studied, the Valkenburgh case and the Gorski case, the courts use these phrases a little bit differently. All right? And I'm going to leave it there for now, but I promise we'll fill in that term with the two cases we studied today. Okay? Questions? Anything? All right, let's do then the von Valkenburgh case. This is a great law school case. I love this case because it involves these crazy families who hate each other for generations. You know, it's like a Hatfield versus McCoy feud. And the backstory of this case is so much fun. So where was I up to? I think, ma'am, what's your name? Victoria. Victoria, tell me what happened here. Don't focus so much on the plots of land here, but just give me an overview. What was the story? What was the conflict between the Lutzes and the von Valkenburgs? Great names.
Lutz bought 14 and 15 first, and they started using other parts of the lot, and they built a house under for Charlie. And so when the other people moved in, they, I guess, bought it, and I guess they're just fighting over those.
Good. Okay, very good. All right, so I reproduced this map on my own, which is based on Google. The streets don't exactly line up with the map in your book. I can't quite figure out why, so I had to draw on my own streets to try and make it make sense. But here was the general gist. At some point in the 1920s, the Lutzes bought lots 14 and 15, and they built a house on it. This street right here, Leroy Avenue, was very steep. So to avoid walking up this steep hill, they started crossing over this triangular-shaped lot, which I drew right here. It's not actually here, it's more like here, but I did this to make it easier. This is 19 and 22, 19 through 22. Okay? So they would cross across, they would walk across this path. But then they started doing a lot of other things. They started building, or what do you tell me? So what else did they do to the land? Uh-huh.
So I don't know if this was before or after they established their easement.
Don't go easement yet. What else do they do to the land? They had a garden, right? What else did they do? Yeah, there was this little. They built a little shack for the brother. What else?
There was also a house.
Yeah, for the brother. Yeah, and they also kept a chicken coop. I whatever that. And they also kept basically a junkyard. They kept a scrapyard. Okay. So, what's your name, sir?
Alex.
Alex. Did they ever even attempt to buy this plot of land? What did they do instead?
They just used it.
They acted like it was their own, right? All right. So, and they were there for I think what 35 years, some really lengthy period of time. All right. So everything was fine. They had this garden. They were making these vegetables. The neighbors didn't seem to mind. Their kids would play in the yard, right? But then, like with the Valkyrie playing, the Valkenburgs moved in, right? Okay, ma'am, what's your name? Suhei? Suhei. What happened after the Valkenburgs blitzed in?
They realized that the Lutzes had created this travelway to come across, and they realized that.
They didn't like that.
No.
What did the Lutzes do to the von Valkenburg children? To the kids? You get that part? You would remember. Ma'am, what's your name?
Danielle?
Danielle, what happened to the kids?
Joseph.
Joseph, yeah.
So the Van Valkenburg's kids were playing in the lot,
Yeah.
and I can't remember if they knocked down something or whatever, they were messing in the garden, and Mr. Lutz came over and chased him off and screamed that he was going to kill him.
He was holding a pipe, wasn't he?
Yeah, he was holding a pipe, and
Yeah.
Mr. Van Valkenburg came back over, and they got in this big argument, and Mr. Van Valkenburg pressed charges for assault.
Yeah.
And
Yeah. So these people they hated each other, right? So so the dude's waving around a pipe saying, "Get out of here, you damn kids! Get off my lawn!" Right? Or something like that. So, all right. So what did von Valkenburg do after this? What's your name? Tyler. So after this incident, what did the von Valkenburgs do to try and solve this problem?
They found an attorney and told the Lutzes to get off the
Before this. What did they try and do with that land, that triangular plot of land? What did the von Valkenburgs try to do?
Oh, they bought it in a foreclosure sale.
Very good. Okay, so they bought it in a foreclosure sale. Now, the book provides absolutely no context, right, what a foreclosure sale is, so I'll fill you in. We'll do this later in the semester. But generally, if a party fails to pay their taxes on their land, or if they have a mortgage which they don't pay, usually the bank will take ownership and they'll hold a foreclosure sale, right? Right? And they sell it to the highest bidder. Okay? So presumably, this land was unowned, right? No one owned it. It was probably just a vacant lot, and the city held a sale to try and sell it off. And of course, the von Valkenburgs, they came in with the highest bid. Okay? So one question which wasn't clearly addressed in the case, but which is relevant, was the sale to the von Valkenburgs valid? Yeah, what's your name? Morgan. Was the sale to the von Valkenburgs valid?
Was the sale?
Yeah. What do you think? Well, let me ask this way. What would make the sale to the von Valkenburgs invalid?
Invalid.
Louder, please. Okay, let's try it like this. If I'm selling something to you, right, what has to happen in order for me to validly sell it to you? Yeah. I have to have it, right? In order for me to sell something to Morgan, I have to have it first, right? Okay. If this plot of land was owned by the city, there'd be no problem with the city selling it, right? But what happens if it wasn't owned by the bank or something? What happens if it's owned by someone else? Would the bank be able to sell it here? No. So here's the rub. If Lutz had acquired that land through adverse possession, was the foreclosure sale valid, Morgan? No. Everyone see that? This wasn't mentioned clearly in the opinion, but it's actually an important fact. If Lutz had acquired the land by adverse possession, the foreclosure sale was void. Lutz owned it. Van Valkenburg could have never bought it. So all of you see that, right? But someone did not see that. Who didn't see that? Lutz's lawyer. He did not sit in this property class, right? What happened? Yonkers lawyer, right? Snooki's from Yonkers. Not a good place, right? Oh, is anyone from New York, by the way? That took about all of an hour. I'm from Staten Island. I admit that with some pride, not much. So Lutz's lawyer futzed up. Lutz futz. And actually, I think the judge's name is Futz also, isn't it? Or Fudd or something, Elmer. So Lutz goes, so Von Valkenburgh goes to court, and he builds this fence, and he says, hey, you get off the land, right? And what's your name? Samaya. What does Lutz reply to this lawsuit? How does he respond to it?
Well, at first he says that it is their land, so but he has the right of way to talk through it.
Exactly. Okay, so the lawyer makes a very significant mistake, which in my mind will be legal malpractice in a heartbeat. Everyone knows what legal malpractice is? If you give very bad legal advice, you are now liable. You can lose your bar license. It's a very bad thing. Okay? So the lawyer, for whatever reason, agreed that Von Valkenburgh owned the land. Why? Why would he make this mistake? The better argument, which I think you probably realize now, would be he's been in that land for 35 years, therefore the sale to Von Valkenburgh was void. Right? If he was there for 35 years, he claims adverse possession, he owns the land. Okay, everyone see that? But he didn't argue that. Okay? Instead, what did he argue? He argued that instead of getting the entire property, he gets what's called a prescriptive easement. Okay, we'll come back to prescription later. And he said easement, which is the right word, but we're not there yet. All that means is that if I cross the same piece of land for 35 years, every day, I keep crossing the same piece of land that isn't mine for every day, right? I have actually obtained a right to cross the land. You can't stop me. So if any of you trespass across a field every single day for a decade, you've now gained the right to do it. You don't own the land. You only have the right to cross it. So maybe you've seen this. Have you ever seen a beach where it said, this is private property, but you can use it with my permission? Anyone ever seen those signs? Why do you think those signs are there? You nodded. Why do you think those signs are there?
Probably because of the prescription.
They want to avoid an adverse possession claim, right? Because what's one of the elements of adverse possession? Hostile. And if there's permission, is there hostility? No. So if you see someone crossing your land every day, perhaps the best thing to do is say, yeah, go for it. You can cross it, no problem. Because that breaks the adverse possession claim. Sir?
I thought beaches were state parks.
I'm sorry?
I thought all beaches, like at least in Texas, were state parks. So
it depends at what point of the beach. There's a certain number of feet from the shoreline that's government property, but further up, you can actually have private property. We're actually going to do an entire discussion of Texas beach erosion cases. Justice Brett Busby in the 14th Court of Appeals here in Houston will be your guest lecturer at some point, I think in November, and he'll give you a discussion of Texas beach erosion cases. Very interesting stuff. All right, so the lawyer fucked up, right? He said, he said that all he's getting was the right to cross it instead of the entire the entire element. Okay. All right. So where was I up to? Yes, so, all right. So what happened after after that case?
So he ends up getting the right to cross.
Yes.
Using the fact.
Okay. Good.
My name's Ty.
Oh, Ty. Thank you. No, Ty. Okay. Thank you. Ty. Okay. Thank you. So in the first suit, it probably turned out the way it should have, right? All he claimed was his right to cross over. He had been crossing land for 35 years. There's not much of a dispute, right? But then he went back to court. Okay, what happened the second go around? What's your name?
Jane.
Jane, what happened the second go around in court?
So they went around saying that they counterclaimed, saying they had acquired it because they had used it for such a long period of time.
Good. Okay, so instead of bringing the adverse possession claim in the first lawsuit, as he should have done, he then brought it on the second lawsuit, right? So did you study in CIPRO something called collateral estoppel or claim preclusion? Everyone remember what that means? Anyone? Yeah, right here. Claim preclusion, yeah.
Well, claim preclusion is where I guess one type is where you already tried that claim, but collateral estoppel is where you say you make one admission, you say something at one time, you're stopped from changing that
Yes.
later on, and just
Right.
rely on it.
So here's the problem, right? The idiot lawyer the first go around made a mistake. He effectively conceded that Van Valkenburgh owned the land, right? What's the significance of saying Van Valkenburgh owns it? Is that what you mean? V. What's the significance of saying that Van Valkenburgh owns the land? Yeah, that he was the correct owner. What's the significance of that? Yes. In other words, by conceding it, he's basically saying that he would need to then go ahead and fight for adverse possession, right? If he had just said in the first instance, we've won this through adverse possession, this would be an easy case, okay? So the majority opinion goes to the adverse possession, and they go through this thing about the, they've already argued this. Let's put that aside for now. Let's walk through the four elements. And what's your name? Brittany. Okay, Brittany. Let's go through the elements, okay? Was there entry? Did Mr. Lutz enter the land? Okay. Was his use of the land open and notorious? Uh-huh. Okay, good. What about, was it continuous?
Yes, because he was on there for 35 years.
Well, what did he do for those 35 years?
Just killed the jump there.
Ah, okay. So what's your name?
My name is Asim.
Asim. Okay. Now, there's no dispute that he definitely crossed it, right? He used it for crossing. What did he do on that land for 35 years?
I'll be honest, I don't have my casebook. I'm going to try.
All right, go for it. What did he do on that land for 35 years?
I'm not really sure.
Okay. What did he do for 35 years?
Well, we could say he did several things. His brother-in-law had a house on that.
Mm-hmm.
He also raised chickens, planted stuff in the garden.
Did the majority think much of those activities?
I don't believe so.
Why not?
Because there wasn't an actual occupation.
Something like that. Ma'am? In the front?
So,
Yes. Yes, do you want me to leave real quick?
Why did the majority not give much credence to the activities being done by the Lutzes, like the chicken stuff? What does the majority say about those activities?
That's not what a normal would have done with the land. Honestly, I disagree with the majority, so I don't quite get their reasoning.
Why do you disagree with them?
Because there was a house on the land, Charlie was living in it, and this guy was gardening in it every day. Well, not every day, but everybody around knew that it was his land, and I mean, he'd even put up a boundary around it. You know, I mean, and he was putting all of these substantial improvements on it. I mean, just because there may be like a small amount of it that's still not cultivated, I mean, doesn't mean that the land isn't in use.
Good. So that's exactly right. So there's this disagreement. What's your name? Clement. So there's this disagreement between the dissenting opinion and the majority opinion, right? And the dissent effectively takes a position that Zoe took. It's like, listen, he's been using this land, he's developing it, he's building the chicken coops and the farming, the whole other garbage, right? Majority's like, nah, doesn't count. Why do you think the majority put such little stop, Clement, in these activities taken on the land?
I mean, they said that they weren't substantially improved over the given time, but the gardening that he did, for the cultivation incidents of the garden would utilize the whole of the premises claim, like that failed to show that it was.
Right, and basically they look at the statute, which I don't really care if you study, but it said you have to use all the property, right? All of it. And they took that literally. So remember I told you the cases before, like that Ewing case where you have a junkyard and only use part of it, and the court held that that's sufficient. That's the normal rule, right? That's the normal rule. But in this case, the majority took a very odd view of the law that put the Lutzes at a very high burden. Okay? Everyone okay on that? Continues. Let's talk about the last one, the under the claim of right. Sir, how did the court handle, what's your name? Daniel, how did the court handle the claim of right title?
It had to be hostile.
Well, was it hostile?
Were they fighting over it? Fight?
In the first lawsuit, what did Lutz say? Who owned the land?
He said he did.
Who's he?
He said Lutz owned
No,
the land.
no. In the first lawsuit, who did Lutz say actually owned the land? What was the mistake that was made?
Oh, the lawyer admitted Valkenburgh owned
Okay, right. So Daniel, if the lawyer admits that Valkenburgh owns it, is there any actual claim of right on behalf of Lutz? Okay, well, the majority said no. So let me walk this through again. The majority said this guy conceded Lutz owned it. I'm sorry, Lutz conceded von Valkenburgh owned it. There's no claim of right. The majority says Lutz would need to say, no, I owned it, right? I'm adversely possessing it. But he conceded the other guy owned it. If you concede the other guy owns it, that means you're not having any claim of right to it. Everyone see that? Why is that the wrong argument? Why does it have to be wrong? What's your name? Heath. Why does that have to be the wrong argument?
Because I guess you would always know that it wasn't your land to begin with.
Yes. Yes. The entire point of adverse possession is you're taking someone else's land. You acknowledge they own it, but I want it. Right? The entire point of adverse possession is that, yeah, this other guy owns it, but I want it from them. That's the entire point.
But that's what saying there before the land had been sold to the band.
So what?
So doesn't it start again? Like maybe the statute of limitations start again now?
Well, the statute of limitations would run again, but during the time when he was obtaining in the first place, von Valkenburgh wasn't even in the picture. Right. So there are two different issues, right? So good. There we go. Take the cookies, right? Attaboy. That's a problem. There's no good way of circulating this. They in the back push around. So there are the two issues, right? It can't be the case that you have to acknowledge the other person owns it. You're trying to get it from them. Now the second issue, what she just brought up, is a fair point, right? At what point? What's your name? Lamar. At what point did von Valkenburgh get adverse possession of the land?
After
whatever.
15 years.
Before von Valkenburgh even got there, right? So effectively, the other argument is he'd already owned it. He'd already gotten it, right? So, man, what's your name? Brooke. If I say to someone, say for example, I adversely possess a piece of land, right? And I say, you know what, Brooke, I'm going to give you the land. It's yours. Who owns it? Why? What's that thing from contracts you hated? Statute of frauds, right? Statute of frauds. It applies in property, right? Just because your lawyer makes an oral admission that you don't own a piece of land, that doesn't do anything. You need to have a writing. Remember the statute of frauds? That's being writing. We have that also in property. There's some overlap, not a lot. Okay? So the mere fact that the lawyer made the mistake doesn't give it up. So the majority was probably wrong on number 3, because they were using the entire land. The majority is probably also wrong on number 4, because they were trying to obtain the land whether they admitted it or not. Okay? Oh, it's Justice Fudd. I thought it was Elmer Fudd. So there's a question. Who would have to pay all the back taxes on the property, right? Well, in many jurisdictions, in order to claim adverse possession, you have to pay the taxes on it, right? Why do you think this is a good idea? And what's your name? Stephanie, why do you think it's a good idea to make the squatter pay taxes? And what else? What else does paying taxes do? And notice. When you pay taxes, you file it in an office, and there's a record of you paying it. So, for example, if my friend who had the retirement community found out that someone else is paying his property taxes, that would be a good clue that that something was up. Now, I don't think Mr. Lutz in this case paid the property taxes, but I don't think under the New York law it was required. Okay? All right. All right, I'll keep going. All right, so the dissent basically said, listen, there's some evidence the land was occupied. That's enough. He cleared the land. He developed a farm. He grew chickens, whatever. Okay, he built a house there. Okay? And the dissent basically said, listen, he had adverse possession before Van Valkenburgh even got there. He got it years before. And because he had it years before, it didn't even matter what happened to this transaction, to this foreclosure sale, because it was void. Okay? All right. Anyway, so but this was the dissent. Okay. So any questions on the case? Yes, ma'am.
So adverse possession, like after they've met all the requirements, means
you own the title. You have it free and clear. Okay. All right. So what's interesting is that it's kind of sad, but if you read the aftermath, right? Because the court ruled in favor of Van Valkenburgh, they awarded attorney's fees. So that snazzy New York Wall Street law firm was very expensive. So the Van Valkenburgs actually were ordered to sell their house to pay the lawyer fees. That sucks, right? The irony. But the court actually saved it due to some kind of procedural error because that same Wall Street law firm messed up the appeal. They didn't appeal the right judgment. So that actually worked out, I guess, kind of okay. Later, New York tried changing the law to make it harder for people to squat because they were repelled by these Lutzes. But as it stands now, it's pretty tough. Okay. All right. Questions on that case? Move on. Yes, sir.
Footnote on 124 about tax foreclosure sales and how usually you receive. That means that you receive the property free and clear.
Well, yes, but not if. Okay, so say for example, let's use Mr. Robinson as an example, right? Bank of America had the mortgage in the house, right? Robinson saved it for 10 years by himself. On year 11, Bank of America holds a foreclosure sale. Who's the owner at that point? I'm asking.
Oh, sorry. Robinson.
Robinson. Did the Bank of America have the power to sell it at year 11? So usually when you get a property from a foreclosure sale, you take it free and clear. But it doesn't work if the bank didn't have it in the first place.
I think the footnote also was talking about how it might have worked, but they didn't give proper notice. And so,
notice to whom?
To the Lutzes.
Yes. Yes. So that's the other issue. With the foreclosure sale, you have to give notice to the record owner. Odds are Bank of America wouldn't send a note to Mr. Robinson if it's a foreclosure sale. So he didn't get the proper notice.
You might already answer this. But say someone is on land for 7 years, the statute of limitations 10 years. Someone comes in and actually buys the land, and they're still using the land, and the statute of limitations start over at the point at which the person actually purchased the land.
Repeat your question one more time. I think I got it, but I got a little lost in the middle.
Okay. Statute of limitations is 10 years.
Okay. Someone's
been there for 7 years. Someone comes in and buys the land.
Ask me that question on Wednesday. Okay. That's in the reading for Wednesday. So there's something called tacking, where you have multiple people who squat continuously. And that's permitted, but that'll be in your reading for Wednesday, okay? Okay. Other questions? Yes, sir.
When we talk about the tax issues, and maybe this is a later, but what if you have like a person who isn't paying their mortgage, but also isn't paying state property taxes? Don't state taxes have primary mortgage if they foreclose on?
Well, I mean, if you have property taxes, that's separate from the mortgage. Yeah, we'll actually do mortgages later in the semester. We'll do mortgages and foreclosures like in maybe about 2 months. So I think that'll make a little bit more sense. And don't get too bogged down in mortgage foreclosure sales. It's a little tricky. All right, other questions? Okay, so I mentioned that a lot of the issue with state of mind is an element. Oh, actually, before I do that, before I go too far, I want to introduce a term called color of title. Okay? Color of title sounds a lot like claim of right. Don't confuse them. I promise you someone will confuse them in the exam. They're not the same thing. Okay? Color of title, what does that mean? Color of title means that you've had some sort of documentation giving you a claim to a piece of land. So the example I gave the gentleman over there at the beginning of class. Someone gives you a fraudulent deed saying, here, you own this property, right? You have this, you think it's real, it looks real, the paper looks real, right? The law treats you better for having some piece of paper. We call that color of title. Okay? And in fact, in most states, Texas in particular, if you have color of title or some sort of document, adverse possession gets easier. So in Texas, there are 3 different statute of limitations periods. And you can find this right here. Okay? This is actually, it's hard to read, but I'll read it. It says, the Texas adverse possession means an actual and visible appropriation of real property, commence and continue under a claim of right, that is inconsistent with and hostile to the claim of another person. Yeah, that's more or less the same 4 elements, just written a little bit differently. Okay? So see here, there's a 3-year period. Notice that Mr. Robinson said 3 years. The reason why he said 3 years was because he was going for this section. He claimed that, remember that affidavit of adverse possession he filed, they showed that piece of paper on the court? He claimed that that was his color of title. Right. It says, blah, 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 under title or color of title. It says it right here. It's a little hard to read, but it's right there. So if you have color of title, the limit's 3 years. And Mr. Robinson thought by filing that paperwork in the courthouse in Denton County, he would be triggering the 3-year clock. So the thing about color of title is it doesn't mean just a deed. It could also be a affidavit you file yourself. The reason why we reward people who do this is that there's some record notice. I can go to the courthouse and find a copy of this document that I see that Mr. Robinson is officially squatting. He said, I'm adding some stuff for my own protection, right? I don't know what the hell he added. I tried to find a copy of it and I couldn't find it. But he did something to try and help himself out. Okay? There's also a 5-year limitation period, which also requires some sort of deed. Don't worry too much about the 3-year or the 5-year. I'll always tell you what the relevant period is with color of title. But generally, on any question, I'll tell you color of title 3 years, no color of title 10 years, whatever I'll tell you. Okay? The 10-year limitation, this is the general one in Texas, is if you don't have any paperwork. You have no record, which means you have to wait the longest. And it makes sense. If there's no paperwork to prove it, we want people to spend the longest amount of time squatting. So had Mr. Robinson not filed that affidavit of adverse possession, he would have been stuck for a decade. Okay? Any questions on that? Not too important. I won't, on any exam, I'll tell you the period with color of title is 3 years and without 10 years, so you don't really need to memorize this, but this might be relevant at some point in your lives. Maybe, maybe not. Okay. All right, so let's go back to state of mind, and we'll wrap up with the Gorski case, right? There are 3 ways of looking at the state of mind. Okay, one of which is called objective, second is good faith, and the third is called the aggressive trespasser. Okay. The more modern approach is that your state of mind doesn't matter. Mens rea, if you will, right? It doesn't matter if Mr. Robinson squatted there to take the property or if Mr. Robinson squatted there as an accident. It makes no difference. If he was there for 10 years, continuous and was open, it doesn't matter. The objective element effectively nullifies the 4th element of adverse possession. It makes it not really that important, right? It doesn't matter why he got there, okay? The second one, which is sometimes called the good faith standard, might be something like inadvertent, right? Where you say something like, oh, I thought I owned it, right? Say there was a mistake, and there was a deed that was messed up, and it said the property line ended here, but it actually ended there, and you were just mistaken where your property was. These kind of inadvertent mistakes are also sometimes allowed. That's kind of more of a modern standard. The common law standard, and of course the Texas standard, is you have to be an aggressive trespasser. Of course that's the Texas standard, right? You have to be aggressive, right? You have to say, you know what? I thought I didn't own it, but I want to make it mine, right? I am knowingly squatting here. Right? This is the person who knows they don't own it and squats anyway. This was more or less the common law standard. Okay, and this is actually the what's sometimes called the main doctrine, and that's how it's called in the dissent. Okay, if you want to break it down like this, the Lutz dissent was objective. It's like, what difference does it make if you knew it or not? Okay, and this is also the view adopted in the Manillo case, which we'll do in 2 minutes. Okay. Any questions on those state of minds? The trend, if there is a trend, the modern trend has been towards an objective or a good faith standard. But common law, Texas, of course, is aggressive. I mean, SOB. Yes, sir.
How is Texas aggressive trespasser if like they have a lower period if you're making a claim on the color of title? Because I guess that would be a good faith.
Well, Mr. Robinson had color of title. He filed an affidavit, right? Color of title doesn't need to be a deed. It can be you file some paperwork yourself. Okay. Yes, ma'am. Well, in that case, it's a good faith standard, right? And in that standard, you have to wait for whatever the period is for the for having a deed. Okay, but you have to at least think that you're owning it, right? Because if you think about it, even if you have a bad deed, that can be something you find out about. You find out you have a bad deed, and you stay there anyway, right? But yeah.
The color of title doesn't have to be something.
No, it could be something. Mr. Robinson filed something himself. He filed that affidavit himself, right?
But does it have to be filed at all?
Probably has to be notarized and filed before.
Like, could it be the fraudulent document itself?
Yeah, it could be. All right. Yes.
But in the Texas standard is that you have to be squatting, and you have to know that you're squatting on someone else's land. Then doesn't that only protect the people who are forcibly trying to take land from others, and then not protecting someone who happened to purchase a house from someone who turned out to be a crook, lives there for 20 years, fully thinks the house is theirs?
Okay, so let me go back to here. Right? Remember where I said under claim of right means different things? This is where it gets messy. You're both right. You can show claim of right by holding a piece of paper, or you can show claim of right by holding a state of mind as being aggressive. These are alternate ways to prove adverse possession. That's why I said this term has multiple cons, right? So if all you're going on is state of mind, then you can show you're an aggressive trespasser. But if you have some paper to go on, you can show, here, my claim of right, I have my fraudulent deed. That make sense?
Okay, so if you have paper, you don't have to worry about the
It doesn't become quite as important, no. It gets very fluid. And that's why at the very beginning I said this context is somewhat fuzzy because it has two different significance. Okay? So then let's talk about the last case, the Manillo case, okay? What happened in this case? This actually happened something very similar to my aunt. You had a situation where over the course of many years, people were living in a house and they built a concrete sidewalk and a concrete set of steps that walked onto the street. And it turned out that the concrete steps crossed the property line by 15 inches. 15 inches, not very much. Okay, so there were a couple elements here to consider, right? Was there entry? Well, yeah, there was entry. The steps crossed the property line, right? Was it continuous? Well, yeah, the steps were continuously there for however many years, and they continually crossed up and down. But the other elements were a little bit trickier. So, right, what was the claim of right? Okay, so here's a situation where there's no paper, right? There's no paper record about whether they had the boundary or not. So, were they considered an aggressive trespasser? No, because they didn't even know they were crossing the line, right? It was almost inadvertent. So, on the claim of claim of right element, the court basically said, we're rejecting the aggressive trespasser doctrine. We're saying that the state of mind doesn't really matter. Whether they intended to take it or not is irrelevant. Okay, everyone see that? So what the court did in this case was they rejected this aggressive trespasser standard. They went to kind of an objective standard. If they use these standards for 30 years, then that's fine. Okay? But where this case went awry is an element number 2, open and notorious. Right? Were they notoriously using the land? And the answer there is no. Why not? They didn't even know they were crossing the boundary line. In order to openly use land you don't own, you have to know that you don't own it. And they had no idea they were even doing this. So even though the court rejected this aggressive trespasser standard, they said, listen, unless they conducted a survey, like a property survey where the lines are, there's no way for them to even know that they were doing this bad thing. There's no notoriety. There's no publicity. No one knew, right? Could the neighbor next door have known that he was being squatted on? No, because there was never a property dispute done. There was never a survey done. So this was an interesting case where the court said, even though the state of mind was irrelevant, doesn't matter, they have to at least know that they're squatting. And that's why in this case they rejected this main doctrine and they adopted the modern approach. All right. I actually had this happen to my aunt, who's lived in the same house with a 3-year break for like almost 60 years. And her neighbor started claiming that he owned the driveway between their houses, even though they had both used it shared for almost 60 years. And I considered telling her, you can make an adverse possession claim, but do you even know for yourself where the property line is? And she was like, no. And I said, did you ever check where the property line is? And she said, no. I'm like, well, odds are, even if you were using this driveway for all these years, if neither of you knew where the property line is, you don't have a good claim for adverse possession. There was no notorious use of the property. So I told her, work it out some other way. And I think that she just let her use it. And by letting the neighbor use it, what happens? There's no hostility, right? It's permissive. If you permit someone to use it, there's no change of property lines. So that's how my aunt resolved that. All right, questions? Questions. We'll do a case in class on Wednesday that focuses on issues of survey and knowing where property lines are. The case from Washington is really messed up. You'll like that one. All right? All right, have a good day, everyone. See you on Wednesday.